Ma'am, I need you to stop resisting right now and get on the ground.
Resisting? I'm standing completely still with my hands in plain sight.
You're being combative. Get down on the ground immediately.
Officer, listen carefully. I'm a sitting federal judge, and you're about to make a very serious mistake.
I don't care who you claim to be. Get on the ground, now.
Your hands are empty. ID's in my car. I'm not a threat, and your body camera is capturing all of this. But understand something. Every second of what you're doing is being documented, and you're violating clearly established law.
Dispatch, this is 4 Adam 12. Stand by for a subject check. Ma'am, don't make any sudden moves.
Reaching slowly, just like this.
The parking lot security camera, Cam 01, recording since 8 a.m., timestamp reading 2025-09-14 at 14:37:29, captured everything, every word, every gesture, every second of what Officer Todd Peterson did and said in the 7 minutes before he understood, completely and irreversibly, what he had done. Peterson had absolutely no idea that the woman he was reaching toward with his hand already extended had spent the last 17 years on the federal bench, presiding over civil rights cases, Fourth Amendment violations, qualified immunity challenges, and police misconduct proceedings that had ended careers and reshaped departmental policy across 2 states. The woman standing at the open trunk of the black SUV wasn't panicking. She wasn't raising her voice. She wasn't doing anything that any camera from any angle would characterize as suspicious. She was Judge Vanessa Caldwell, silver-haired, sharp-eyed, wearing a camel wool coat over a cream turtleneck, white gloves on both hands, standing beside a trunk full of cardboard boxes with the composed expression of someone who had presided over enough courtrooms to recognize the precise moment a situation became a legal matter. She had written opinions that became binding precedent. She had sentenced officers who had done exactly what Peterson was doing now, and she was about to become the plaintiff in a civil rights lawsuit that would cost the city $1.2 million, end Peterson's career before it reached its 3rd year, and produce a security camera exhibit that a federal court would review in its entirety without requiring a single word of explanation from anyone who had been present. Before we go any further, drop your city or country in the comments right now, and if you believe that authority without accountability is the most dangerous combination in any society, hit that subscribe button before this video ends. This story gets more consequential with every chapter, and you will not want to miss what happens next. Vanessa Caldwell was not a woman who expected deference. At 58 years old, 17 years into a federal judicial appointment that she had earned through 2 decades of legal practice before the nomination, she had developed the specific professional orientation of someone who had seen enough of how power operated, at its best and at its worst, to have stopped being impressed by its symbols and started being interested only in its application. She was fair, she was thorough, she was known in the legal community of the Southeastern Federal Circuit as the judge whose written opinions were the most carefully reasoned and the hardest to overturn on appeal, not because she was inflexible, but because she did the work that made flexibility unnecessary. That Saturday afternoon in September, Judge Caldwell had been running the kind of errand that fills a Saturday afternoon when the week's work has been set aside and the ordinary logistics of a life need attention. She had driven to the retail complex on the north side of Crestwood in her black SUV, purchased several items she had been meaning to get for 3 weeks, and had returned to the parking lot at 14:35 to load her purchases into the trunk. The SUV was hers, registered, insured, current tags, key fob in her right hand. The boxes in the trunk were retail purchases with receipts in the shopping bag beside them. The parking space was a standard public space in an open commercial lot. No restrictions, no reservations, no signage that any reasonable reading of the available information would have produced a question about. She was dressed for a Saturday, a camel wool coat falling to mid-thigh over a cream turtleneck, silver-framed glasses, white gloves because the September afternoon carried the first genuine chill of the season, her silver hair framing the composed, direct expression of a woman who was thinking about nothing more consequential than whether she had left enough room in the trunk for the last box. She was doing exactly what thousands of people do in parking lots on Saturday afternoons across the country, loading purchases, preparing to leave, occupying a public space she had every right to occupy, drawing no attention from anyone in the lot, except the one person whose attention was going to cost the city $1.2 million. Officer Todd Peterson had been with the Crestwood Police Department for 2 years and 4 months. His personnel record described him as motivated, assertive in field situations, and proactive in identifying potential enforcement opportunities, the same vocabulary that had appeared in the personnel records of officers in several of the cases that Judge Caldwell had presided over from the federal bench, which was the kind of institutional irony that the security camera footage would preserve without commentary for anyone paying close enough attention to notice it. He had one prior informal counseling notation in 2 years, a flag related to an enforcement contact that his supervising officer had described as initiated without sufficient observable basis and resolved without formal discipline. It had not been reviewed again since the day it was filed. He was walking the retail complex perimeter at 1436 when he saw the black SUV with its trunk open and a black woman in a camel coat loading boxes into it. His body camera activated as he changed direction toward the parking lot. The security camera on the building's exterior wall, Cam 01, was already recording from above, capturing the lot in the wide, unblinking way that fixed security cameras capture everything within their frame without editorial selection or interpretive preference. Peterson crossed the parking lot toward Judge Vanessa Caldwell with the purposeful stride of someone who had already formed a conclusion and was walking toward the moment of applying it. The security camera recorded his approach in its entirety. The timestamp advanced. And the woman at the trunk of the black SUV, who had spent 17 years on the federal bench and had written binding opinions on the precise constitutional questions that the next 7 minutes were going to raise, continued loading her boxes without looking up, because she had no reason to look up, no reason to anticipate what was crossing the parking lot toward her, and no reason to expect that a Saturday afternoon errand was about to become the most consequential 7 minutes of Todd Peterson's 2-year career. Vanessa Caldwell had presided over 412 federal cases. Not approximately 400, 412, a number her clerk had mentioned at her 15-year bench anniversary dinner, delivered as a piece of institutional trivia that was meant to be impressive, and landed instead as a reminder of how much the work had accumulated without ever feeling like accumulation. Each case had been a discrete world, its own facts, its own legal questions, its own human beings whose lives would be shaped by the quality of attention she brought to the record. She had brought the same quality of attention to all 412. That was not modesty, that was method. Her reputation in the Southeastern Federal Circuit rested on a specific foundation, not the volume of her docket or the profile of her cases, though both were considerable, but the consistency of her reasoning. Attorneys who appeared before her knew that preparation was not optional and that the quality of their arguments would be met with the quality of her questions. Her written opinions were studied in law schools. 3 of them had become binding precedent in 2 states. One had been cited by the Supreme Court in a footnote that her former clerks still referenced at every reunion dinner as the closest thing to a standing ovation the federal judiciary was capable of producing. She had sentenced 2 police officers to federal prison in 17 years. Both sentences had survived appeal. Both written opinions had been clear enough that the appellate court's affirmations ran to a single paragraph each, the judicial equivalent of nothing left to add. None of that was visible on a Saturday afternoon in September. What was visible was a 58-year-old woman in a camel wool coat and cream turtleneck, silver-framed glasses catching the afternoon light, white gloves on both hands because the September chill had arrived with the specific conviction of a season that had made up its mind. She had parked her black SUV in a standard public space in the retail complex lot at 1431, walked into 3 stores over the course of 40 minutes, and returned with several cardboard boxes that she was now loading into the open trunk with the methodical efficiency of someone who had been managing the logistics of her own life without assistance for 58 years and had no intention of stopping. The purchases were unremarkable. The parking space was unremarkable. The woman loading boxes into a registered vehicle with a key fob in her hand was, to any honest reading of the observable situation, completely unremarkable. This is the lesson that Saturday afternoon had been quietly building before Todd Peterson crossed the parking lot. That the most consequential thing about Vanessa Caldwell in that moment was not her coat or her glasses or the boxes in her trunk or the SUV or any of the visible details that Peterson was processing as he changed direction toward her. The most consequential thing was the 17 years of federal jurisprudence she was carrying in her mind while she loaded her purchases, unbothered, into a car that was entirely hers on an afternoon that was supposed to be entirely ordinary. She closed the first box into the trunk and reached for the second. The timestamp on Cam 01 read 14:36:47. Peterson was 40 feet away and closing, and the 413th case of Vanessa Caldwell's federal career was 53 seconds from beginning in a parking lot, without a courtroom, without a bench, and without anyone present who understood yet what they were walking into. Peterson had been walking the retail complex perimeter for 40 minutes when he saw the black SUV. His assignment that Saturday was standard commercial detail, a visible presence in the retail corridor designed to deter shoplifting, manage parking disputes, and respond to the occasional noise complaint from the restaurant section on the complex's north end. It was not investigative work. It did not require him to identify criminal activity from a distance, initiate contact without observable cause, or cross from his assigned perimeter into the open parking lot based on a conclusion he had formed before gathering a single articulable fact. The assignment was presence, visibility, the reassuring background machinery of law enforcement operating within its appropriate scope. Peterson had a different understanding of the assignment. 2 years and 4 months on the force had built in him the specific enforcement instinct that his personnel file called proactive, and that his one prior counseling notation had described in more precise language as initiated without sufficient observable basis. He had been flagged once. The flag had not been discussed with him in any sustained or consequential way. He had continued operating the same way the flag had documented on every subsequent shift, because the absence of further consequence had communicated to him in the only language that modifies behavior reliably that his instincts were sound. He saw the black SUV at 14:36. Trunk open, boxes visible. A black woman in a camel coat loading purchases into the cargo space with white-gloved hands. He registered the vehicle first, the specific late-model luxury SUV that his 2 years of commercial detail had trained him to associate with a particular category of concern that his training had never formally defined, and his counseling notation had already questioned once. Then he registered the woman. Then he registered the combination of the two, and arrived, in the time it takes an assumption to dress itself as an instinct, at a conclusion that the observable facts did not support. He changed direction, toward the parking lot, toward the SUV, toward the woman with the white gloves and the cardboard boxes, and the key fob visible in her right hand. The key fob that was the single most unambiguous piece of observable evidence available in that parking lot, communicating in the universal language of automotive ownership that the person holding it had authorized access to the vehicle she was loading. Peterson saw the key fob. He kept walking. The lesson that moment teaches, before a word is spoken, before Cam 01 captures anything beyond a man in uniform crossing a parking lot with purpose he hasn't earned, is about the specific danger of an instinct that has never been corrected. Peterson's prior notation had named the problem 12 months earlier. Nobody had followed up, and the instinct that the notation had flagged was now carrying him across 40 feet of open parking lot toward a federal judge who had sentenced 2 officers to prison for conduct that the next 7 minutes were going to document as entirely consistent with theirs. Cam 01 recorded every step of the approach. Peterson had not looked at the camera housing once. Peterson reached the SUV at 14:37:29. Cam 01 captured the approach from above, the specific angle of a fixed security camera that records geometry rather than perspective, showing the spatial relationship between 2 people with the kind of objectivity that neither of them could provide about the encounter afterward. Peterson stopping beside the open trunk, Caldwell turning from the boxes, the white-gloved hands visible at her sides in the universal posture of someone who has just been interrupted doing something entirely ordinary and is waiting, with measured patience, for an explanation of why. He didn't provide one immediately. He asked what was in the boxes. Caldwell looked at him with the particular expression that 17 years on the federal bench had built into her as a default response to questions that lacked a legitimate basis. not hostility, not alarm, but the precise evaluative attention of someone who was already assessing the legal and procedural dimensions of the interaction before the interaction had produced enough information to assess. She told him they were retail purchases from the stores she had visited in the previous 40 minutes. She gestured toward the shopping bags beside the boxes. The receipts were visible in the closest bag. Peterson asked whose vehicle it was. Caldwell held up the key fob. She said it was hers, registered in her name, and that if he needed verification, she could provide the registration from the glove box. She said it with the calm, transactional efficiency of someone offering the fastest resolution to a question that shouldn't have required asking. Then she told him, in the same level tone, that she was a federal judge and that she would appreciate knowing the basis for the inquiry before it continued further. Peterson looked at her for a moment. Then he did the thing that Cam 01 recorded with the kind of clarity that makes subsequent characterizations of the moment irrelevant. He smiled, not warmly. The specific smile of someone who has decided that the information they have just received doesn't change anything about how they intend to proceed. The smile that communicates without words that the credential being offered has been evaluated and found insufficient to alter the existing conclusion. He said that anyone could claim to be a judge. Caldwell removed her right glove. She reached into her coat's interior pocket and produced her federal judicial identification, the credential that carried her photograph, her district designation, her appointment seal, and her name in the formal typography of a document issued by the United States courts. She held it where the afternoon light caught every detail and where Cam 01, recording from above, captured its presence in the frame with the same impartiality it had applied to everything else. Peterson looked at it the way he had looked at the key fob, registering without revising. His conclusion had been formed in the parking lot before he reached the SUV. The key fob hadn't changed it. The judicial credential wasn't going to change it either. He had arrived with a story, and he was going to need considerably more than a federal identification to let go of it. He told her to step away from the vehicle. The lesson that moment delivers is one that the federal bench had been articulating in written opinions for decades, that the most dangerous exercise of authority is the kind that has already decided its conclusion and is simply moving through the motions of justification. Peterson had not approached the SUV to investigate. He had approached it to confirm what he had already decided. The credential was not new information to him. It was an obstacle. And the smile that Cam 01 had captured 30 seconds ago was the precise moment the encounter stopped being a misunderstanding and started being a choice.
Caldwell placed the credential back in her interior pocket with the deliberate care of someone preserving an exhibit. She looked at Peterson with the steady, unblinking attention she had directed at 412 cases from the federal bench, the attention that saw everything, recorded everything, and had 17 years of practice converting everything it recorded into a legal record that held. She told him he was making a serious mistake. He told her to step away from the vehicle again. She stepped away, because she understood with the precision of someone who had presided over enough misconduct cases to know how the next chapter needed to read, that compliance was not surrender, it was documentation, and the camera above them had been running since 8 a.m. Peterson reached for his cuffs at 14:39:12. Cam 01 recorded the motion from above with the same unhurried objectivity it had applied to everything preceding it. The unclipping, the presentation, the closing of the distance between Peterson and Caldwell that transformed the encounter from a verbal confrontation into a physical one. Caldwell did not move away. She did not raise her hands in the performative surrender that panic produces. She stood with the specific stillness of someone who had already made a decision about how this moment needed to be documented and was executing that decision with the same methodical precision she brought to every proceeding she had ever managed from the bench. She said, clearly and at a volume that the body camera's audio captured without distortion, that she was a federal judge, that she had committed no crime, that no probable cause existed for an arrest, and that the physical contact Peterson was about to initiate would constitute unlawful arrest under 42 U.S.C. Section 1983. The federal civil rights statute that she had applied from the bench in 17 separate cases, and that Peterson, based on everything the next 30 seconds was about to demonstrate, had never read. Peterson applied the cuffs anyway. Here is what the law says was happening in those seconds, stated plainly, because the footage captures the actions and the statute captures their meaning, and the combination of the two is what a federal court would later spend considerable time examining. A warrantless arrest requires probable cause, a reasonable belief based on articulable facts that the person being arrested has committed or is committing a crime. Peterson had no articulable facts. He had a luxury SUV, a black woman loading boxes, and a conclusion he had formed 40 feet away before gathering a single piece of evidence. The key fob was evidence of authorized access, the receipts were evidence of lawful purchase, the federal judicial credential was evidence of identity. Every observable fact available to Peterson at the moment he applied the cuffs pointed in the same direction, and that direction was not probable cause. What Peterson had instead was assumption wearing the procedural clothing of enforcement. And assumption, regardless of how confidently it is applied, is not a legal standard that authorizes the physical restraint of a person in a public parking lot on a Saturday afternoon. Caldwell's hands were cuffed behind her at 14:39:31, 19 seconds from the motion to the restraint. Cam 01 recorded all 19. Her expression, captured in the body camera footage as Peterson turned her toward the SUV, was not the expression of someone experiencing the moment emotionally. It was the expression of someone cataloging it. The same expression she brought to testimony she found significant, to exhibits she intended to return to moments in a proceeding that she knew were going to matter when everything else had been argued and the record was all that remained. She was already building the record. In the parking lot, in the cuffs. 19 seconds into the unlawful arrest that would become the foundation of a federal civil rights complaint, a $1.2 million settlement, and a written legal opinion, authored not by Vanessa Caldwell this time, but by a colleague on the federal bench who would later describe Peterson's conduct in language so precise and so damning that his attorney would advise him not to read it. The lesson the statute delivers in those 19 seconds is not complicated and does not require a law degree to understand. Probable cause is not a feeling. It is not a pattern recognition instinct that a 2-year officer develops on commercial detail. It is a constitutional standard with a specific definition, a specific threshold, and specific consequences for the people who apply it incorrectly on a running camera in a public parking lot in front of a woman who has spent 17 years deciding what those consequences look like. Peterson had applied it incorrectly. Cam 01 had the timestamp, and the woman in the cuffs had the case law memorized. The call reached the chief's office at 14:52 p.m. Not through the standard dispatch channel, not through the duty sergeant's radio, directly to Chief Raymond O'Coffer's personal department line, the number that existed for communications that could not afford the lag of normal routing and could not risk being misheard in the background noise of a busy precinct Saturday afternoon. His administrative assistant transferred it without explanation, which was itself a form of explanation, because transfers without explanation from that particular line on a Saturday meant whoever was calling had the number and the specific urgency that justified using it at that hour.
The caller was the federal courthouse's duty administrator. She had received a call 12 minutes earlier from a clerk who had received a call from someone who had been in the retail complex parking lot at 14:39 and had watched the encounter from 30 feet away with a phone already in hand. The footage had been texted to the clerk before Peterson's transport vehicle had cleared the parking lot exit. The clerk had watched it once, identified the woman in the camel coat from 17 years of federal court appearances, and called the duty administrator without putting the phone down between the viewing and the dialing. The duty administrator gave Chief Okafor 45 seconds of information. She did not raise her voice. She did not use inflammatory language. She delivered the facts in the specific, organized sequence of someone who understood that the quality of the next decision depended entirely on the clarity of the information preceding it. Federal Judge Vanessa Caldwell, arrested. Currently in transport. No charges filed yet. Parking lot security camera running. Body camera running. Witness footage already in circulation. Okafor was on his feet before she finished the sentence containing the word transport. He covered the distance between his office and the watch commander's station in the specific, contained urgency of a 20-year chief who had managed enough institutional crises to know that the difference between a recoverable situation and an unrecoverable one was almost always measured in minutes, and that the minute counter had been running since 1439 without his knowledge, which meant he was already behind, and every subsequent second of inaction was compounding a deficit that the department's legal team was going to spend months trying to address. He told the watch commander to locate the transport vehicle immediately. His voice carried the flat, definitive quality of someone who has assessed a situation completely in the time it took to walk across a room and has no remaining patience for anything that isn't a direct response to a direct instruction. The watch commander made the call. The transport vehicle was 4 minutes from the precinct. Okafor told him to have it stopped where it was. Then he called the city attorney. The lesson that the next 4 minutes delivered to every person in that precinct who was paying attention is the one that institutional accountability teaches at its most unguarded, that the speed with which an organization responds to its own mistake is the first and most visible measure of whether it takes the mistake seriously or takes its own protection seriously. Those are different responses. They produce different outcomes. And the chief, who was already on his phone to the city attorney before the transport vehicle had been stopped, was making a choice in real time about which kind of organization the Crestwood Police Department was going to be in the public record that CAM-01 had been building since 1436. Peterson's transport vehicle stopped 2 blocks from the precinct at 1496, 17 minutes after the cuffs had gone on in the parking lot. 17 minutes in which a federal judge had been sitting in the back of a transport van for loading boxes into her own car on a Saturday afternoon. Chief Okafor was already in his vehicle. He drove the 2 blocks himself. The formal complaint was filed on Monday morning, not the following week, not after a recovery period or a strategic consultation about timing. Monday morning, 39 hours after Chief Okafor had personally removed Caldwell's restraints on a residential street 2 blocks from the precinct, delivered an apology that she had received without comment, and watched Peterson's body camera be removed from his chest and placed in an evidence bag by a supervising officer who had arrived with the chief and had not spoken a single word to Peterson during the entire process. The complaint was drafted over the weekend by Caldwell herself, reviewed by 2 colleagues from the federal bar, and submitted simultaneously to the Department of Justice Civil Rights Division, the city's Office of Inspector General, and the federal court's Judicial Conduct Oversight Body. 3 separate institutions receiving the same document at the same moment, ensuring that no single review process could contain the outcome. The civil lawsuit followed 4 days later, $1.2 million. The claims were constructed with the specific precision of a federal judge who understood, from 17 years of reviewing complaints, exactly what made one survive the motions to dismiss that defendants filed reflexively in the first 60 days of civil rights litigation. Unlawful arrest under the Fourth Amendment. Racial discrimination in the exercise of official duties under the Equal Protection Clause. Deliberate indifference to established constitutional standards by the department. The institutional claim that required demonstrating not just what Peterson had done, but what the department's supervisory structure had failed to do with the prior counseling notation that had named his pattern 12 months before the parking lot. That notation was the lawsuit's structural foundation. One prior flag, never followed up, never incorporated into any subsequent evaluation, never used to trigger the additional supervision protocol that department policy technically required for officers with documented pattern concerns. Peterson had been cleared for solo commercial detail with an active counseling notation in his file that nobody had read since the day it was written. The lawsuit made that gap visible in the kind of precise, documented language that the department's legal team reviewed and immediately understood was a gap they couldn't argue their way around. The city attorney recommended settlement before the first scheduled hearing.
The settlement negotiations lasted 3 weeks. The city's opening position was significantly below $1.2 million. It did not remain there. Caldwell's legal team had the parking lot security footage, the body camera footage, the witness phone recording, the counseling notation, the transport log showing 17 minutes of a federal judge in a transport vehicle, and a plaintiff who had spent 17 years on the federal bench reading settlement offers and understanding precisely what the evidence behind them was worth. The city settled for the full amount, $1.2 million, entered into the public record with a consent agreement that required immediate policy revision, mandatory bias training for all officers assigned to commercial detail, a formal supervisory review protocol for any officer with an active counseling notation, and the creation of an independent civilian oversight panel with genuine investigatory authority, the kind of panel that could pull records, identify patterns, and ask the questions that Peterson's prior notation had never been asked before the parking lot made them unavoidable. Peterson was terminated the same week the settlement was signed. His appeal to the termination board lasted 1 session. The board had the footage. They had the notation. They had the 17-minute transport log. His attorney requested a recess after the footage was played and did not return with a substantively different argument when the session reconvened. The termination was unanimous. His supervising officer, the one who had signed Peterson's commercial detail clearance without reviewing the counseling notation, received a formal written reprimand and a mandatory supervisory retraining requirement. The department's Internal Affairs Division opened a broader review of all active officers with counseling notations that had not been incorporated into subsequent evaluations. The review identified 7 additional cases. 3 produced supervisory actions. The lesson that $1.2 million delivered to the Crestwood Police Department was not the lesson about Todd Peterson. Peterson was the consequence. The lesson was about the notation, the flag that had been written accurately, filed correctly, and then left in a folder where it could not do the work it had been designed to do. Accountability systems are not self-executing. They require someone to open the folder. The city had paid $1.2 million to learn that the folder existed and that nobody had opened it in 12 months. Caldwell's legal team made sure the consent agreement required someone to open it going forward, every time, for every officer, before the next assignment was signed. Vanessa Caldwell returned to the federal bench on Tuesday morning. She had not requested additional time. She had not communicated to the court administrator that the weekend's events required an adjustment to her schedule or a reduction in her docket or any of the accommodations that the institution would have extended without hesitation if she had asked. She had filed the complaint on Monday. She had reviewed the draft lawsuit with her colleagues on Monday afternoon. She had prepared for Tuesday's hearing on Monday evening the same way she prepared for every hearing, with the complete, undivided attention of someone who understood that the cases on her docket belonged to people whose lives were waiting on her work, and that her work did not stop because something had happened to her. The hearing ran 4 hours. Her written order was filed by end of business. What Caldwell chose to address publicly in the weeks following the settlement was not the personal experience of 17 minutes in a transport vehicle or the specific indignity of being handcuffed in a parking lot while loading her own purchases into her own car. She had processed those things in the private, internal way that people process things when they have spent 17 years developing the discipline of separating what happened from what the record needs to say about it. What she addressed publicly was the structural question, the one that the settlement's consent agreement had begun to answer and that she believed required a wider conversation than one city's policy revision could contain. She said that Cam 01 had changed the outcome of her case. Not her judicial credentials, not her 17 years on the bench, not the federal identification she had produced from her coat's interior pocket while Peterson smiled at it. Those things had mattered. They had accelerated the chief's response, shaped the lawsuit's damages calculation, and given the story the specific irony that made it travel across every platform it reached. But they had not been the reason accountability arrived as quickly and as completely as it did. The camera had been the reason. She said that the uncomfortable truth underneath her story, the one that the $1.2 million and the termination and the consent agreement did not fully address, was that she had been fortunate in a way that required honest acknowledgement. She had credentials that were verifiable, an institutional weight that commanded a response. She had a legal education that allowed her to cite the statute governing her arrest while the arrest was happening. She had colleagues who recognized her from 30 years of professional proximity and made calls before the transport vehicle reached the precinct. Most people have none of those things.
Most people who are handcuffed in parking lots on Saturday afternoons for loading boxes into their own vehicles do not have a federal appointment, a duty administrator on speed dial, or 17 years of civil rights jurisprudence available as a real-time reference. They have the same constitutional rights, the same Fourth Amendment, the same probable cause requirement, the same 42 U.S.C. Section 1983 that Caldwell had cited at the moment the cuffs were applied, but without the vocabulary, the institutional connections, and the resources to convert those rights from abstract protections into enforceable outcomes. What they have, increasingly, is a camera. Caldwell said the witness phone footage had reached the courthouse clerk before the transport vehicle cleared the parking lot exit. Cam 01 had preserved a time-stamped record that no subsequent account could revise. The body camera had captured audio that made the written incident report's characterization of events legally indefensible before the ink was dry. 3 cameras, operating simultaneously, had produced a record so complete and so consistent that the department's legal team had not attempted to dispute the facts, only to negotiate the price of them. She said that accountability required a witness, that the badge alone had never been sufficient, not because every officer who wore one was Todd Peterson, but because the systems designed to catch the ones who were had demonstrated, repeatedly and expensively, that they functioned only when the evidence was undeniable. The camera was making the evidence undeniable at a scale and a consistency that internal review processes had never achieved. It was not a solution, it was a pressure. The specific pressure of documentation so complete that the gap between what an officer reports and what actually happened became, for the first time in the history of these encounters, a gap that the record could reliably close. She returned to the bench the Tuesday after the settlement was finalized. Same courtroom, same docket. The 413th case had been resolved, not from the bench, but in a parking lot on a Saturday, with white gloves and a key fob and the specific composure of a woman who had known from the moment Peterson crossed the lot toward her that the most important thing she could do was remain exactly who she was and let the cameras finish their work. The 414th was waiting. She called the room to order at 9 a.m. The work continued. If this story held you from the first timestamp on Cam 01 to the last sentence of Caldwell's statement, if it made you think about what the camera catches that credentials alone cannot guarantee, about what changes when the documentation is undeniable, about what remains unchanged when it isn't, share it with someone who needs to hear it. Stories like Vanessa Caldwell's exist because 3 cameras were running simultaneously in a parking lot on a Saturday afternoon, and a witness pressed record before the transport vehicle cleared the exit. We tell them because the people who don't have 17 years and a federal appointment deserve the same outcome when the cuffs go on without probable cause. If you want more stories about power, accountability, and the moments when the record refused to be rewritten, hit that like button right now. Subscribe to this channel and tap the notification bell so you never miss a video. We post stories exposing racial profiling, police misconduct, and the people who made the system answer for what it built. Every story is documented. Every one matters, and we are nowhere near finished.